thinking last night about this case and their theory and how it didn't make any sense and how it didn't fit and how something is wrong. It occurred to me.
We, the jury, in the above entitled action, find the defendant.
It's no disguise. It's no disguise. It makes no sense. It doesn't fit. If it doesn't fit, you must acquit.
We throw good.
Attorney Andrew Wilkerson here with my illustrious colleague, as he always says, Attorney Michael Campbell. Best opener you ever see. You understand? Like one of them pictures you put up there and just throw a non-hitter. How you feeling, Mike?
Hey, I'm feeling good, man. Looking forward to having a good show. Appreciate you with the introduction, my boy. You know, Not Guilty Boyz. We're here to bring the law to the culture, you know, give you our legalese expertise and advice on how you should be navigating yourself when you're dealing with these legal situations in life. So I'm feeling good.
Yeah, man, we're going to be talking about on this show Proposition 3. Basically something that was voted on in Texas in November of 2025. We're going to tell y'all what it means. We're going to give y'all our take and opinion on it. We're also going to talk about this executive order that Trump put out and a few more things, man. We got Legalese and me coming as well. Looking forward to it, man. Let's go.
Yes, sir. One of the most important things that I wanted to talk about you, my people who live in Texas. Oh my gosh. This is why it's so important to get out and vote. Back in November, there were some constitutional amendments that was proposed to our Texas Constitution that could affect everyone's legal rights. And one of those, Proposition number 3, had to deal with the denial of bail bonds. And it's denial of bail bonds in regards to violent offenses. So like your murder, your ag assault, kidnapping, sexual assault, human trafficking. It used to be, the Texas Constitution said all persons charged of offenses were entitled to a bond. Not anymore. We didn't vote that down. As a matter of fact, 61%, I think, of people voted for Proposition number 3, which I can see why it's good in certain circumstances. You don't want a serial killer out on the streets. However, for the person who was defending themselves in an ag assault or a murder, who ain't never been in trouble before, now they are no longer entitled to a bond by a magistrate judge. And in order to get a bond, they have to hire an attorney to file a motion to set a reasonable bond. You file a motion to set a reasonable bond with a district judge. That means that you're going to have a hearing for a bond to be set. That district judge can deny you being able to make bond on that charge, and you'll have to sit in jail all the way up into trial. Okay. Also at the hearing, whatever bond that judge set, if he does decide to set a bond, that's going to be your bond. It ain't going to be too many. Well, can y'all see about a bond reduction? We had our hearing to set a bond and our bond reduction hearing all in one. And that district judge discretionary made this decision to set you a $50,000 bond on each charge. So you got to make that bond. It ain't going to be no bond reduction. But the problem with this law passing, as I see as a legal scholar, is that law is going to be misinterpreted. It's going to be used discretionary by judges. I've already seen it. Judges holding people charged with mandate. They're not giving them bonds. Some people who got charged with a manufactured delivery of drugs. That doesn't fall under specific violent offenses. But when you use that type of language, a judge can interpret that to mean what they want it to mean. So they can interpret to say, well, I feel like distributed judge is violent against people, so now I'm not going to give you a bond for Mandel. I think we have entered into a place we may not want to be when it comes to bail bonds, giving these judges too much power to decide what case deserves a bond and what case does not deserve a bond. And if they actually give you a bond, they got to put it right why they giving you a bond. You're going to have a lot of judges not give people bonds just because they don't want to write their reasoning out or explain themselves. I've known a lot of judges who just make rulings and gives no explanation. They don't want to give verbal explanations. They damn sure ain't going to want to give a written explanation as to why they made their ruling. So you're going to have a lot of people deny bonds just because of lazy judicial work. Drew, what do you think? Proposition 3, now in effect.
I think you hit the hammer on the nail, man. shout out Providence bail bonds, first of all, first and foremost. If you do
Right
get a
on.
bond, they'll be there. We still doing the branding, but have some common sense. Call Providence. That just came to mind. I just kick it
Okay.
to you like that.
Yeah. So,
Judges are already misinterpreting these bonds. I mean, this proposition. But let me talk first. Well, let me finish my thought. They're already misinterpreting it. They actually listed out the violent offense. See, that's the thing. That's why you got to make sure you got to come to Not Guilty Boyz and watch each one of these judges we put on here, tell you what they stand for so you can get a gauge on their personhood and what type of people they are and what type of decisions they will be making. Okay? Because that's what judges do. Soon as you give them a little discretion, they go all the way down in a rabbit hole. Okay. These judges are now saying, like Mike said, offenses that they view to be inherently violent, right? But it says right here, it says capital murder, aggravated assault causing serious bodily injury, aggravated kidnapping, aggravated robbery, aggravated sexual assault, indecency with a child, and human trafficking. They give you a list. Now, it's not exclusive, but they give you a list to go off of. Now, you tell me how the hell Mandel made it on that list. You see what I'm saying? That is an arbitrary way of thinking that this certain judge has engaged in. And arbitrary means I'm going to just do it because I want to do it. That's what arbitrary means, in case y'all ain't know. But, I think it's dangerous. I think that the list should have been exclusive. I think it should have been exclusive, just like it used to be, or still is. For capital murder, they don't have to give you a bond. You see that? It ain't for capital murder, and anything that you view as inherently violent is capital murder. You don't get, no. It's for capital murder. You don't have to get a bond. You are not entitled to a bond. They should have made it exclusive. But that's the little bullshit that the legislation does, right? These folks sit down there and they vote on laws. They go back and forth like two little kids in a sandbox, and then they don't even get it right when they done. You see what I'm saying? That's why I'm really not a political guy. I don't really, but we ain't got to go there neither. But that's why I'm really not, because the shit be for nothing. You see what I'm saying? All they had to do is concentrate and get a exclusive list of what charges fall under that purview. But no. Let's make the judges feel good too. Let's cater to the judges, right? And let them do some deciding too. No, because you want to know something that everybody don't know? Every police officer ain't smart. Every fireman ain't smart. Every prosecutor ain't smart. Every defense attorney ain't smart. Every judge ain't smart.
No, for real.
You see what I'm? No, seriously. Like, it's a level of intellect and morality that has to do this. It has to come together, and then you make sound decisions, right? Judges get up there and make decisions based on how they day going, just like any other person in any other profession. Any other profession. So understand that there's a method of there's human error that comes into all this. That's why you got to make sure that people got morals. You got to know what people believe in. You got to know what they stand on. You got to know what they lean on. Sometimes you may not take this position, but I do. You need to know who they pray to. You understand what I'm saying? So, understand, yes, this law is already being misinterpreted. I think that it poses a problem, as far as judges that want to be too discretionary, judges that just can't let shit go. And I think that it's backwards. Mike, didn't you say if they give you a bond for this, they have to explain themselves?
Yeah, if they give you a bond.
That shit is backwards. That shit is an incentive for them not to give you a bond. So they don't have to explain themselves. Because I know y'all watch a lot of TV. I know y'all watch a lot of Perry Mason and Law and Order and such. But judges do not like to explain themselves. As important as it is for judges to explain themselves, like Mike said, that's why I started laughing. Like Mike said, judges make rulings and they get mad when you ask for a basis of their ruling. Oh, because that's my ruling. Well, what's the premise, Judge? What's the reason that you made that ruling? So I can fully understand and know how to combat that next time. And they get angry with you. I've had a judge threaten me with contempt because I'm simply asking, what's the reason for the ruling? Why was I overruled, Judge, if I may? Why weren't they overruled, Judge, if I may? See what I'm saying? So giving judges too much discretion, giving anybody that doesn't know how to properly use their power too much discretion is a dangerous deal. It's a dangerous deal. Even police officers, even when the shit, y'all remember when all of a sudden, you can't be arrested for weed no more. Y'all forgot the part where it said it's at the discretion of the police officer. So niggas still going to jail for weed just because the law want to take you. You understand what I'm saying? So I got a big I got a big problem with that, with giving people too much discretion, because everybody can't handle power. Power corrupts people in the craziest of ways. You know, that's why I tell people when they ask me why I don't run for judge, I don't like to sit up high and look down low. That ain't my thing. You see what I'm saying? It's just not my thing. I'd rather be in the trenches with the people. I'd rather be helping the people in the trenches that's trying to make it out instead of sitting them. And look, if you're good at being a judge, if you're good at that, then power to you. Thank God for you. You see what I'm saying? And I'm not saying I don't want to do it because I don't think I'd be good at it. It just ain't something I want to do. See what I'm saying? I was always a person getting told on, going to the principal's office, get my name wrote on the board when the teacher go to the bathroom, all of those shit. So I've always been the person that want to speak up for others, not the person you got to explain yourself to. That's just me. You see what I'm saying? Now, let's talk about the effed up legislature just a little bit more. I think that one of the things that the legislature does wrong, completely wrong, is that they don't spoon feed these things to the people. They don't explain these things to the people in a manner to where they'll understand what they're voting for. You got to understand,
Right.
sitting at a ballot, you in the ballot, people waiting in line behind you, that's pressure. People doing it next to you, you know, you wondering what they picking. Are you picking the right thing? That's pressure. You know, the old lady at the old lady gang that walked you to the ballot and whispered you somebody you should vote for, you trying to find their name. It's all kind of pressures at the ballot. I think that being at the ballot should be one of the most straightforward and elementary things that you do is possible. And when I say elementary, I mean the language of it. Let me read you this proposition language. Let me read it to you. Support amending the state constitution to require judges or magistrates to deny bail to individuals accused of certain violent or sexual offenses that are punishable as a felony if it is demonstrated after a hearing through a preponderance of the evidence that the accused will likely, not willfully, that's not confusing at all, will likely, not willfully, appear in court or by a clear and convincing evidence that the accused is a danger to the community or victim. Let me tell you, Pookie at the barbershop don't know what the hell that just said.
Come on now.
Miss Pat, everybody got a lunch lady, Miss Pat. Miss Pat, lunch lady, she don't know what that means. You see what I'm saying? We all know people that are intellectually challenged. We all know people that are intellectually intrigued. You see what I'm saying? I love looking up shit in the dictionary when I don't know what it means. On the other hand, I got a partner that will sit here and ask me to tell him what it means. And sometimes that annoys me because I'm like, bro, it's right here for you. And guess what? If I tell you, you're going to ask me again tomorrow. But if you read it, you done learned it. You see what I'm saying? But everybody's not like that. Matter of fact, I would venture to say most people not like that. All this thing had to say, all it had to say is require judges not to give bail to offenders for violent or sexual offenses that have a history of not coming to court or they pose a danger to the community. That's all it had to say. It ain't have to say nothing about a preponderance of evidence standard. It ain't have to say nothing about a clear and convincing. That is legalese, ladies and gentlemen. That is lawyer. That is lawyer writing. That is lawyer literature, if you will. I was a double major, criminal justice and English. I love English. Everybody don't love English. So you got to understand, giving you a quick, you have to, if you're a trial attorney, right? You have to know how to spoon feed a jury. You got to, and what that means is explain it to them in a manner where they understand it. Right? You can't say, you know, when you're trying to argue self-defense, if you believe my client was imminent, the danger was imminent. Everybody don't know what imminent means. If you believe my client was in danger right then and there, the danger was present right then and there in that second, right? That's explaining it to somebody who can understand it. You see what I'm saying? So for them to put this on there and want you to vote for it, I think that is a big F up on behalf of the legislature. And I think it's a way that they trick our people into just circling B. For some reason, when you had a Scantron test, if you ain't know the answer, go B. For some reason, go B.
Right.
I know niggas that didn't even read the question if it looked too hard. They just going B. They going B. And people do that at the ballot. I think that people do that at the ballot when they don't understand. And I think a large percentage of the people didn't understand. Do y'all understand, black folks? What's the percentage, Trip? 61% of people voted for this. 61% of people said you should not give these people bail. When 100% of people that's in jail want a bail. That's a fact. You understand what I'm saying? So there's some kind of disconnect there. So my point to you is don't be scared. And honestly, it's so crazy. I was finna say, don't be scared to. Can you come here, please, man? What do this mean? What do this one mean? I don't even know if you're allowed to do that in voting, are you?
You're not.
See,
You're
that's crazy. So if
You're
you're not allowed to ask the teacher for help, the teacher needs to talk in layman's terms. She needs to talk to you like you a kindergartner, okay?
No.
Because if you only at a 6th grade level and the writing, the legalese, the literature is at a 9th grade level, you need somebody to explain that shit to you.
Come on now.
Or they could have that writing and then they could have an explanation under it.
Yeah.
But guess what? They ain't got time for that shit either.
No.
You see what I'm saying? So I'm just trying to put that on your mental, man. Just think
the
about that.
legislature knew what they were doing and make it too difficult for people to read, and I understand it. And get them to just vote one way or the other just because they don't understand. Shout out to Jazz, my wife. She put me on because we voted in that election for those propositions. And she put me on and gave me a cheat sheet that broke down because, before, she was like, we need to read these propositions before because the language is tough. Okay. And so I read it. I was like, damn, this is straight legalese type language. The average Joe not going to understand it. So she said, here's the average Joe interpretations of it right here. And she gave me a little cheat sheet that broke down what the language actually meant in layman's terms. But most people that had that cheat sheet at the ballot, and I was there, and it was taking people like 20 minutes to take that, to do the ballot, because it's a lot of reading and you got to understand these words. And I know most of the people didn't have a cheat sheet ahead of time. It was one guy who finished it in like 5 minutes. I kind of gave him the side eye, like, bro, come on now. You didn't read out.
He went B.
You remember cheat sheet.
He went B, Mike.
You went B the whole time. Yeah, I gave him the side eye, but yeah, I think that was a play by the legislature. Let's put this constitutional language on this ballot that most of these people won't understand because it's written in the old English jargon, and let's confuse them and get them to vote how we want them to vote because they confused. And that's what's so messed up about Proposition 3 in and of itself, because it is a constitutional amendment. They are changing the law in our face. They changed the Constitution in our face. Something that's been here since how long Texas has been a state? 1847, some shit like that. That's how long that law been in effect. And in 2025, they changed it to say, no, all persons are not entitled to a bond. Now it is discretionary for a judge to decide if he's going to give your baby a bond. Imagine your baby, church boy, ain't never been in no trouble, coming home from Sunday school, vacation Bible school, whatever choir rehearsal. Somebody roll up on him and he's licensed to carry, and they pull that thing out on him. So he got to handle his business. So he getting charged with murder because we know that the threshold to get arrested is very, very small. Okay, so he get arrested for murder. Now he has a no bond. Bail is the very beginning of the criminal story. Bail bonds, and that's the very beginning. His legal justification don't really come out in the bail setting process. So really, he got to get an attorney right away to stump down right away that this was self-defense. I'm talking about for the times that they put the handcuffs on him. He got to have an attorney stumping down self-defense to get that judge to understand why he's entitled to a bond, unlike all these other people that y'all try to lump in a category and try to say they all violent offenders so they don't deserve a bond. That's what the law is basically saying. But there are good people who may get charged with these same charges, and now they got to lay down. Mama, unfortunately, your son got to lay down until we get to trial on this. Mm-hmm. That is messed up. That changes the whole trajectory of the criminal justice system, and I think there's going to be more injustice than it is going to be justice with that law now becoming effective. So mamas and daddies, tell your kids to be careful. Okay, the type of, you can't get into it with your female now and slap her up and get a ag assault or something because you threaten her with that thing, because now you ain't gonna get no bond. And that just may have been a 30-minute emotional heated situation. Now you got to sit for the next 9 months waiting on your trial date or waiting on your plea. Tell your kids to be careful with this new law. And when it all boils down to it, if you get charged for any of these charges, the first thing you need to do is pick up the phone and call Wilkerson and Campbell. You need to get a good lawyer on the phone right away if you get charged with these charges that the state is classifying as a serious violent offenses, and you don't get a bond. You need an attorney. You need a good attorney right away. Pick up the phone and call Wilkerson and Campbell and let us help you navigate through that process and get your baby home. And that's the bottom line. You're going to need a good attorney on your side right away. Okay, man, we appreciate y'all for continuing liking, sharing, and watching our show. We're looking forward to a big 2026. We plan on having judicial candidates on during this election season. This is a very important year. A lot of turnover in the judicial seats here in the Dallas Fort Worth Metroplex. So we look to have judicial candidates on our upcoming shows. We bring you their platform, their campaign, what they stand for, who they are as a person, and why we need to get them elected to the bench. Also, people running for district attorneys. We're going to have that coming up on our shows. We appreciate y'all tuning in, sending your legalese and me questions. Drew, you got any closing words?
Yeah, man, we're running out of legalese and me questions, man. We're running out of good ones. Send them to our IG at Not Guilty Boyz. Please subscribe on YouTube. We're on all platforms, all podcast platforms. Look, y'all sitting in beauty shops, barbershops, sit up in these game nights, man, talking about how bad the law is and legal system and how we need some change. Well, we bringing the candidates right to your doorstep, all right? At least when y'all go to the ballot now in 2026, y'all know what these people stand for. I think primary is about to start, and then you got the big election in November, man. So leading up to there, we're gonna keep giving it to you, man. Tap in.
Yeah, we got some very, very special guests we trying to work out and get them on the show. Well, we ain't gonna say no names right now, but we're talking about some heavy hitters in the legal justice system here in Dallas Fort Worth. Yeah, any candidates that want to come on the show, we'll be more than happy to have y'all on. Y'all just hit us up on our Instagram page or hit us at Wilkerson and Campbell or notguiltyboyz@gmail.com. Any one of those emails are good. So y'all continue to pray for us. We pray for y'all in 2026. Looking forward to our best year yet. We're going to get out in the community. Y'all going to see us live at some events. Y'all going to see us at some of these fundraisers, some of these campaign fundraisers, supporting the people that we believe should be on the bench. So again, we appreciate y'all. Not Guilty Boyz. Check it out.
Above entitled action, find the defendant.
It's no disguise. It makes no sense. It doesn't fit. If it doesn't fit, you must acquit.
We can throw good.
In this case, been convicted of at least one crime of murder of the first degree and one or more crimes of murder of the first or second degree to be not true. Ladies and gentlemen of the jury, is this your verdict? So say you one, so say you all.